Hello, everyone, and welcome to the special internet edition of Power of Attorney. I'm Shauna Sanford, along with attorney John Redmann, and our guest today is attorney Dean Sutherland, and we're talking about the big topic of bad faith when it comes to dealing with insurance companies. And we know that there are a lot of folks out there who have been in a situation where they felt like they've been treated unfairly by their insurance companies. Dean, it's great to have you here. Thanks so much for being a part of the show. And I know that one thing that we really want to talk about is what happens when damage is done and it exceeds the policyholder's limit with their insurance company. That could be a really big problem.
Yes, and on the this is the internet, but on the one that's being broadcast in the episodes, right, we didn't talk about this. So this is another topic that I think is very important.
Very.
This doesn't come under the two statutes that we talked about on the broadcast show, but as the judge-made law of a duty of good faith and fair dealing, both to the insurance company's own insured and third parties, this law arises. So it's judge-made law. Okay.
Okay.
If an insurance company, let's say a person is involved in an accident and it's your fault and you hurt somebody badly, right? And you have a limited amount of let's make it a car wreck to make it easy. You have a limited amount of auto liability insurance. If the insurance company could have settled that case within the limits of coverage under your policy and don't, and then the case goes to trial and the person who's injured gets a judgment for you for more than the amount of your insurance company, the courts will look at whether the insurance company was in bad faith if they didn't have a good reason to not settle the case. And the consequence is that if, under those circumstances, the insurance company was in bad faith and not settling within the policy limits when they could have, the insurance company is going to have to pay the entire judgment, even if it's more than their policy limits.
Yeah, and Shauna, let me add to that, or let me add on to that. In my world, it's a common occurrence. You know, there's very often, my client is the injured person. The other driver, and we mentioned it on the TV broadcast, one of the episodes, very often people in Louisiana don't have big insurance policies. My client, as an example, car accident, is seriously injured. We find out that the other driver doesn't have a very big insurance policy. Well, normally, I'll let my client know, look, it's, thank God you're alive, but you do have serious injuries. The other driver doesn't have a very big policy. The best thing is we let the lawyer or the adjuster for the insurance company know if you will just pay up the insurance, 100% of the insurance. With that money paid up, without us having to spend a lot of money and wait a long time and go through all the rigmarole of trial, we'll take that money, and in return, the insurance company is going to say, you accept 100% of the insurance policy, and in return, client signs on the dotted line that says, case is over. The at-fault driver who caused all the harm is off the hook entirely. And that's typically how it works. But sometimes, in my experience, and this is a common experience across the, other plaintiff lawyers will tell you the same thing. Insurance companies say, well, you got a lot of injuries here, but we don't think you guys all that hurt, and it's kind of a joke. And I go, wait a minute, look at the medical bills, look at the positive MRI findings, look at the this and the that. There's no way this case is worth less. And this is typically where nobody's arguing who had the green light, who had the red light. What Dean is describing is, if that insurance company who's on the hook for the fault caused by the at-fault driver fails to settle, if we, the injured party, the attorney for the injured party, gives the insurance company at fault the opportunity to cough up, pay 100% of that policy, and they'll try and lowball. Oh, well, we'll give you 90% of the dollars. We'll give you 75%. But we want to keep some money back, which is profits for the insurance company. I mean, that's money saved. Then my perspective, and what I tell the insurance company is, look, if you don't pay, here's what's going to happen. We're going to refuse to take 100% of the policy later on. I send a certified letter, and tell me, Dean, if this is not your own experience, what happens out there in the real world, I send a certified letter. Give me 100% of the policy now. I've given you the proof of loss. There's not a liability concern, or not realistically a liability concern. And if you don't send the money, we're going to withdraw our offer to settle for policy limits. And if you don't, then you are putting your own insured, you're putting that at-fault driver, you're putting his neck on the chopping block. you're doing that to your own insured, and you're violating your duties to your own insured. Now, I can't speak for your insured right now, but you're doing that. And later on, I can say I told you so, and then I can take my judgment against your insured, step into the shoes of your insured, and say, look, I can collect this against you personally, or you can assign your rights to me. I can seize your rights, sue your own insurance company. And your insurance company is going to have to pay the whole tab.
Yeah, has that been your experience? Do you
Oh,
agree
yeah.
with all of that?
Oh, absolutely. And in fact, the source of it, though, is the other driver, the at-fault driver's insurance company's obligation to their insured. They really have limited obligations to the injured party, but they do have an obligation to their own insured to put that insured's interest at least the same as their own. In some cases, they say even greater. It's a fiduciary obligation, but it's even greater. They have to look out for their insured.